tend to see it as raw as this.
Good evening and welcome.
And among other things, Harvey had testified that Black was dead for about 12 hours before he was dismembered. So there is a lot to break down here. And joining me this morning is crime journalist Pat Lalama, as well as criminal defense attorney Jeffrey Wolf. It's great to have you both here. And Jeff, it's interesting because he also stood up, or not stood up, but he told his attorney that he intends to make John Lewin look like a fool on the stand when he decides to take the stand and testify. That was quite a statement that he made. And by all accounts, even though he is not in the same shape as he was a year ago or even a few weeks ago, he's going to take the stand and testify.
Yeah, and I would say it's pretty hard to know what shape he's actually in. I think he has shown over the years that he can paint himself in whatever light he wants to paint himself, whether it's, dressing as a woman and living as a woman, or shaving his head in the old trial and putting his chair down. So it's hard to know what's an act and what's not an act here. But it is a trial lawyer's nightmare to have your client talk loud enough for everyone to hear it. And this is something that's been rampant on WebEx trials over the last year and a half, is you'll sit and listen into some trial and then text a friend and say, hey, everybody can hear you and your client talking on this WebEx. And so it is an absolute disaster. And the client control here is lacking.
Jeffrey, is it tough for a defense attorney to fight these multiple battles, right? They're trying to say that, hey, look, Kathy Durst, she might not have even been murdered, and my client definitely didn't do it. Susan Berman, he didn't kill her. He saw her body, panicked, ran away, but he didn't kill her. And here with Morris Black, he was acquitted, and we really shouldn't be talking about this, and it has nothing to do, he wasn't on the run. They're fighting these multiple battles. What do you think it's like for the defense attorneys here?
It's an absolute nightmare. You don't want to have to fight these battles, and quite frankly, you shouldn't have to fight these battles. Rule 404B is clear that character evidence is not admissible except for a very limited purpose of plan, motive, scheme, or pattern, as was just talked about. And this does not show a pattern. The methods of killing are not the same, so they don't show modus operandi. And because he was acquitted of the actual murder, what does self-defense have to do with him trying to knock people off who know about the disappearance of his wife, allegedly? And how do they prove that Morris Black knows about his wife? And that is the issue here. And so for the defense, it is an absolute nightmare to have to fight these battles. And the rules of evidence say that you shouldn't have to fight these battles. And that's the crux of this entire case and the prosecution's theory and what the judge has allowed in that likely will come up on an appeal.
The morbid thing to think about in terms of an appeal, because we've talked about a number of different weird issues in this case, is could Robert Durst, if convicted, even survive to get to an appeal and a possible new trial? That's a whole separate issue. We're going to take a break. When we come back, we want to get into some more of the testimony that you might have missed from this past week. Stay with us.